I rise on behalf of the Labor Party to talk about this extremely important issue of the National Redress Scheme for institutional child sexual abuse. Labor will be moving a number of very sensible amendments, and I will speak to them in some detail in a moment. But it's true to say that survivors of institutional child sexual abuse wait too long for redress. It's been 2 years since the National Apology to Survivors and almost a decade since the announcement of the Royal Commission by the Gillard government in November 2012. We asked people to bare their souls, to dig up old and painful memories, and they did. We said to them, "We hear you and we believe you." We also made a commitment that our words would be backed with action, a commitment to deliver redress. Survivors have been through so much, it is unimaginable. We had a commitment to deliver redress that was timely, redress that does not re-traumatise, redress that does not leave survivors missing out. 31 months since the commencement of the scheme, a fraction of the projected numbers of survivors have received redress, and I will outline that in a moment. There are still too many waiting. Many are ill, many are old, and many are dying. In fact, we know that some have passed. Many have missed out altogether. It is time for us in this Parliament to get redress delivering on its promise to survivors. To make it better with these amendments, I seek to do so. Labor will introduce a series of amendments to address the long-standing structural and emerging issues with the National Redress Scheme. The scheme that was ultimately rolled out by the government did not fully realise the recommendations of the Royal Commission. But I hasten to say that I do believe that everyone in this chamber, on both sides of the House, are absolutely committed to redress. There is no question about that. Labor's amendments will better reflect the reality of survivors and the spirit of the original recommendations. And I ask, Mr Deputy Speaker, that the government carefully consider these amendments. I am genuine in putting them forward, and the Minister knows that, and I respect the Minister very much. I have met with her to talk through Labor's amendments. Fixing the National Redress Scheme should not be put in the too hard basket, and changes do not need to jeopardise any aspects of the scheme. This gives the government, and I stress this gives the government latitude and flexibility to work constructively with, and we will work constructively with the government to get the scheme working and delivering to survivors as was originally intended. The bill makes largely administrative amendments to the operation of the National Redress Scheme, and we welcome those administrative amendments. This includes making the process of identifying related groups of institutions more straightforward, by simplifying the Minister's power to declare related institutions. This will mean large institutions can be referred to by a single name rather than as many legal entities, for example, the Anglican Church. Clarifying that the amount for which a funder of last resort is liable is based on the number of funders of last resort for a defunct institution. And we saw during the summer break the issues that arose at the Retta Dixon home in the Northern Territory. Allowing senior executives of the department to appoint independent decision makers rather than the Minister. allowing for the faster appointment of decision makers, protecting the names and symbols associated with the National Redress Scheme, which are being misused for commercial purposes by some lawyers and organisations. And I say, Mr Deputy Speaker, that those organisations and those lawyers need to have a good, hard look at themselves. Permitting a redress payment to be made to a person who has been legally appointed to manage the financial affairs of an applicant for redress, for example, a court-appointed guardian, and allowing the National Redress Scheme operator to extend the time institutions have to make payments to the scheme, and this is important. Authorising the disclosure of protected information about a non-participating institution for the purpose of encouraging the institution to join the scheme and correcting typographic errors. And also Labor supports, I want to say very much, Mr Deputy Speaker, that Labor supports these amendments, but we also believe that this is an opportunity for the Parliament to address major structural shortcomings of the scheme. The original Royal Commission estimated some 60,000 survivors would be eligible for redress. That's a lot of people. And as of the 15th of January 2021, the scheme had received 9,232 applications, had made 5,487 decisions. They'd finalised 4,660 applications, including 4,620 payments, totalling approximately $385.2 million. In June, we know that there were 512 applications on hold, waiting on institutions to join the scheme. These delays are a further trauma to the people who are waiting, and those institutions that still have not signed up should get their roller skates on. The anxiety many survivors are experiencing at the possibility of missing out altogether due to their age or illness is also a further form of trauma. The slow rate of applications indicates that the scheme is difficult to navigate, inadequate and hard to find. This is what we have been certainly told by those people who are trying to navigate the scheme. Survivors have spoken of the difficulty in preparing an application. The Joint Committee on the Implementation of the National Redress Scheme heard that for one survivor, it was 17 months to finalise their application. And given the age and given the fact that many of these people are extremely vulnerable, that is just too long. The application processing time by the scheme itself is a separate matter. For example, applications received in the first half of 2019, the Department of Social Services said that the average processing time was about 8 months. At estimates in October, the department advised that the averaging processing time was actually between 12 and 13 months. Institutions simply not signing up to the scheme, despite being named in applications for redress, is another major reason survivors are waiting in limbo for their application to be processed. And I do acknowledge that the Minister, prior to Christmas, very much named 6 of those recalcitrant providers or institutions. There is currently no mechanism other than through civil claims to compel institutions to join the scheme so that they can be held to account. Labor supports the changes the government's made to charities law last year, as I just indicated, to prevent organisations getting government grants and removing charitable tax deductibility status if they refuse to join the scheme within 6 months of an application being received. However, these changes will not guarantee that people will get access if any institution remains recalcitrant and refuses to join, or if they deliberately restructure their affairs to avoid the obligation joined by hiding assets. And this particular issue, Mr Deputy Speaker, I find absolutely abhorrent, that institutions that have responsibility for past trauma actually are going about restructuring themselves so that they cannot be accountable to this scheme. I have had concerns raised with me, particularly for the Chamber to understand, that the Jehovah's Witnesses are doing this at the moment. It is absolutely reprehensible. In these rare cases, we are calling on the government to consider placing a levy on such institutions in order to cover the cost of redress and collect funds from these institutions through the tax system if need be. Survivors should not miss out on the opportunity to get redress because an institution refuses to take responsibility. It might seem unbelievable to those of us in the Chamber that there are such institutions, but I can assure you there are. And I am sure that people in this Chamber would be very aware of some of those institutions. I know the member for Lingiari is going to actually address that issue in his comments. Many applications are in limbo because institutions that are the subject of applications are now defunct or have no present-day links or entities. In other cases, application for a redress cannot be progressed because the institution itself does not have the financial capacity to meet obligations under the scheme. A notable example is the Redress home in the Northern Territory, as I said earlier. This is where governments need to step up and provide a guarantee that they will act as funders of last resort. We don't think there are going to be many cases like this, but they do exist, and people in the terrible situation of having suffered abuse at the hands of that institution, which is no longer viable, should not miss out on redress, which is why the funder of last resort is such an important point. No one should miss out on access to redress, get the redress scheme, because the institution responsible for their abuse has folded or simply cannot afford to pay. Now, Labor's amendments will seek to ensure governments act as funders of last resort, when people would otherwise miss out because institutions are defunct or do not have the capacity to join the scheme. And I say particularly to the government, we don't see, and I know that you've done some work on this, we don't see that there are hundreds and hundreds and hundreds of these cases, but these cases certainly exist out there in the community. Labor's amendments are calling on the government to establish an advance payment scheme for people who are elderly or ill. Now, this is very important. There is a model that we've based this amendment on, and it exists in, I think it's Scotland, Mr Deputy. It is Scotland, Mr Deputy Speaker, where there is the capacity for government to make an advance payment for those people that are incredibly ill or getting very old. This could be similar to the scheme, as I said, that it's currently being used in Scotland, which has been well received by survivors over there. So there is a working model that the government could actually look at in relation to an advance payment scheme. It wouldn't cost any more because the advance payment would, of course, be considered in the final calculation of the person's redress, and it has no financial implications, but it would be an incredibly important process to put in place given the advanced age and the illness of some of the people we're talking about. Given the decades and years that many survivors have waited for a chance at redress and justice, it is vital that people do not die waiting. People deserve to see that institutions who have done them so much harm are held to account. They deserve to know they are believed, they have been seen, and they are taken seriously. Another major issue with the design and implementation of the scheme is the inadequacy of redress payments. Inadequate payments, in particular the 150 cap on payments, are pushing people towards civil processes and away or outside of the scheme, where hearing survivors can get a more generous payment while receiving these payments in similar timeframes to the scheme. This issue is undermining the fundamental purpose of the scheme, which is to make it easier and quicker for survivors to access payments and support. Redress payments are also being significantly reduced because of prior payments, and I know the Minister is very aware of this. The Joint Select Committee heard an instance by which a payment was reduced by $50,000 to $20,000, all because the survivor was awarded a payment of $15,000 years prior. For example, it might be prior payments to stolen generation survivors, a separate issue for institutional child sexual abuse, or being used to reduce payments. We know that, and I urge the government to carefully look at this. The indexation of prior modest payments is also seeing redress payments reduced. According to the interim report, the Joint Select Committee, the Department of Social Security advised that as at February this year, 449 payments have been adjusted due to prior payments, with the average value of the adjustment being about $34,500. DSS also confirmed that the maximum adjustment made was $150,000, which reduced the redress award to zero. Now, that just is not right. To that end, Labor's amendments would lift the cap on redress payments from $150,000 to $200,000 as recommended by the Royal Commission. Labor's amendments will also ensure that prior payments are not indexed when calculating a redress payment, and that prior payments which do not relate to institutional child sexual abuse are not deducted from redress payments, for example, payments to members of the stolen generations. The redress assessment matrix has also been widely criticised, particularly by care leavers. As the Joint Committee found, the assisting assessment matrix arbitrarily links the amount of redress awarded to the physical type of abuse perpetrated. It fails to recognise the lifelong harm that any sexual abuse has on survivors. Of grave concern was the decision to limit the payment of exceptional circumstances to penetrative abuse. This approach fails to acknowledge the harm caused by other types of sexual abuse. This was a noted departure from the original recommendations of the Royal Commission. One survivor stated, "I don't know how they came up with the matrix." Labor's amendments will require the Minister to remake the redress assessment framework to properly recognise the impact of abuse when calculating redress payments as recommended by the Royal Commission. The limited one-off payments for psychological counselling and support is contrary to the recommendations of the Royal Commission. We are concerned that in many cases, people are being provided with as little as $1,250 to cover future counselling and psychological care. Originally, the Royal Commission recommended that ongoing support should be provided, not one-off payments. It said many survivors will need counselling and psychological care from time to time throughout their lives. Counselling is not necessarily needed continuously throughout a survivor's life. It should be available throughout a survivor's life. It should be available on an episodic basis, and I know people understand that in this chamber. To that end, Labor's amendments will ensure that necessary ongoing psychological counselling and support will be provided to survivors. Often we hear a claim from the government that they can't make changes to the scheme on their own, and that's a very true statement, that they need the support of states and territories, and I acknowledge this. Of course, agreement is needed for certain changes, but so is leadership, so is action from the Commonwealth, which is incredibly powerful within that process. Improvements will not happen in a vacuum. Just as this scheme and the Royal Commission that was asked to make recommendations on it did not happen in a vacuum. They happened because there was leadership from the top, leadership from Prime Minister Julia Gillard. The legislated 2-year review of the scheme is due to report soon, and we know that talking to survivors, that the issue reflected in Labor's amendments has also been raised as part of that review. Only the government, and I'm pleased to see Minister Fletcher in the chair, only the government can move amendments that have a financial impact. That is why Labor has put forward a series of amendments that require the Minister to investigate change and report back to the Parliament. This is a sensible and flexible approach for the government. There is absolutely no reason why the government should not support these amendments. They afford the Minister and the Prime Minister the time to talk to jurisdictions and institutions, consider the 2-year review and report back to the Parliament on what they will do to fix problems with the scheme. As I said, Deputy Speaker, I am very genuine in putting forward these amendments. The scheme as it currently stands fails to deliver on the promise of redress for everyone. Timely redress that does not re-traumatise, redress that does not leave survivors missing out. The reality is the redress scheme as rolled out does not reflect and falls short of the original recommendations of the Royal Commission. The amendments Labor has put forward seek to address major structural shortcomings of the scheme by bringing the scheme back in line with those original recommendations. We want to end the delays caused by institutions not doing the right thing and not joining the scheme. We want to ensure no one misses out through strengthening funders of last resort provisions and the introduction of an advance payment scheme. We want to deliver full redress to survivors by lifting a cap on payments as prescribed by the Royal Commission, and make sure prior payments are not indexed to take away from a redress payment, including members of the stolen generations. Scrapping the existing misguided and arbitrary assessment matrix and delivering one that is fair and properly recognises the full impact of sexual abuse, particularly psychological and lifelong impact. Ensuring ongoing psychological support for survivors throughout their life. After so long, it is time that we in this chamber deliver on the promise of redress for survivors.
Could I ask the Honourable Member for Barton to move the amendments in her name?
Mr Deputy Speaker, I move the amendments circulated in my name.
Move the second reading